questions I get a lot about CDRs, like, how do I avoid this or how do I win it? Well, I don't know if you can avoid it. It's triggered by Social Security. How do you win it? One thing you need to do is to continue to seek medical treatment post-entitlement. What we see sometimes is our clients, after they win, they stop going to their doctor as much. They stop seeing their doctors altogether sometimes. And after 2 to 3 years, Social Security is going to send you a letter saying, we're going to review your case. And you're required to authorize them for your medical records, or they'll cut you off for not giving them that authority. Welcome to the Evans Disability Podcast. We hope to be your definitive guide through the Social Security Administration landscape. I'm Peter Evans, your host and managing partner at Evans Disability, a law firm that handles disability cases throughout the United States. Before we dive into today's episode, I want to mention a special resource for our listeners. Click the link below to receive a free SSA disability guide from Evans Disability. This guide is packed with details on SSA disability programs, expert tips for winning your case, and sample questions from actual disability hearings. Join me as I sit down with special guests, including experienced lawyers, our extremely well-trained staff, and even a former Social Security law judge. If you find our content useful, please hit the like button and don't forget to subscribe to stay updated on our latest discussions. I hope you enjoyed today's episode. So that's the other thing, kind of what options after you win. And the last thing I want to kind of cover is just app and recon options to winning is 2 to 3 years down the road, things to think about if you've won your case. And specifically what I want you to talk about is potentially a CDR. What does that mean? And how do you, because I know you've done some CDR hearings at the local office.
Yeah.
Why don't you talk to folks a little bit about just generally, and we can have a whole other podcast about CDRs, but generally just kind of, if you won, what are your options and what things to look out for?
Yeah. So CDR stands for Continuing Disability Review. Essentially, this is Social Security. Usually it would start maybe about, I would say, 3 years, 2 to 3 years after you've been found disabled. But it can happen later, or it can even happen earlier. It's Social Security taking a look at your case again to see what it says. Is your disability continuing? They're reviewing your case to see if you still have the medical and if you still meet those medical and non-medical requirements for disability benefits. You'll usually be notified in the mail that your case is being reviewed. And then eventually you'll get another decision from Social Security saying either, yep, your disability is continuing, or they'll say that we believe your disability has stopped, your benefits will stop at some point, and it will have appeal rights there as well. I agree. I think this is an entire podcast worthy thing to discuss because it's something that you don't want to sneak up on you unexpectedly. I think in your experience, Mr. Evans, you've said before that if you are a younger individual in Social Security's eyes, which is anyone under the age of 50, the odds of having a CDR happen to you at some point in your life pretty much approaching 100%. And I think the administration admits this, that their priority when they're doing these reviews is for folks who are younger, because you have the potential of collecting more over the course of your life in disability benefits than someone who is older. So that is something that can happen. Your case being reviewed, potentially them saying that your disability has stopped. That would be called a notice of cessation. So even more than just your case being reviewed, this is something to be aware of and to take action on. Is when you're told your disability has stopped, your benefits will also stop, and if you disagree, you have a limited window of time to file an appeal. If you get your appeal in fast enough, we might even allow you to receive your ongoing benefits until a final decision is made on your ongoing disability.
Right. And
like you said, we could deep dive into this in a whole nother podcast, and we will. But just quickly to answer, the questions I get a lot about CDRs, like, how do I avoid this or how do I win it? Well, I don't know if you can avoid it. It's triggered by Social Security. How do you win it? One thing you need to do is to continue to seek medical treatment post-entitlement. What we see sometimes is our clients, after they win, they stop going to their doctor as much. They stop seeing their doctors altogether sometimes. And after 2 to 3 years, Social Security is going to send you a letter saying, we're going to review your case. And you're required to authorize them for your medical records, or they'll cut you off for not giving them that authority. And so they'll order your medical records. And if there's no medical records there to order, you're likely going to be stuck in a hearing calling our firm to represent you. Yeah. And there's a lot of firms that don't take CDR cases or post-entitlement review type cases or overpayment cases because there's no back pay in it. And we'll do a whole podcast on how lawyers get paid, but in this field of law, but it's on a contingency and it's only based off of back pay. There's no future. Their lawyers are not entitled to money out of your month-to-month check moving forward into the future. So just to briefly answer that question, if you're going to be if you want to win your CDR, just keep seeing your doctor. And if you improve, then great. You probably make way more money working than you ever will on Social Security. Yeah. And if you don't improve, you better have the evidence to prove it.
Yeah, 100%. And I'd say as a quick aside to that as well, being mindful of the need for ongoing medical treatment, being also mindful of Social Security's rules about returning to work or attempting work. In the late 90s, Congress passed this act to try to incentivize folks who are on disability to go back to work. It's part of the Ticket to Work program. It's voluntary, but it has, again, all sorts of little bits of fine print that could come back to bite you if you thought, oh, yeah, I can attempt work and have it protected. There's fine print involved in that. It's wonderful to feel like I've got the health that will allow me to at least try dipping my toe back into the job market and seeing if there's a job out there that I could hold down more than just a little bit of part-time work. But be aware of the ways Social Security will look at that and could potentially say your benefit stopped because of having worked and earned too much for too long to remain eligible for Social Security. So another wonderful thing to deep dive into regarding all of these issues, because once you get that favorable decision, it's not necessarily the end of your complex relationship with Social Security.
I think it's really important that even after you win, you read the mail that Social Security sends you, because it will outline sort of your obligations post-entitlement.
Yeah. So if you've hired a lawyer, a law firm, they will stop getting copies of your mail. So just because you hired a lawyer in the past, this is Social Security's decision. They'll just stop sending your lawyers copies of your mail. And depending on the law firm you hire, they may stop providing any type of assistance. They may wash their hands and say, look, our agreement was for winning your claim. Your claim is won. Best of luck going forward, but there's no services that you can expect from us any further. That's not what we do at Evans Disability. Please reach out to us if you're a client of ours who won and then you got something confusing in the mail or alarming. It's better to inform us early, because we're not going to get copies of that from Social Security in all likelihood. So we can't be proactive in letting you know there's something important from Social Security.
I think there's a CFR, or it's a PALMS, I can't remember, that says that after entitlement and award of benefits have been approved, Social Security automatically says we no longer represent the claimant after 60 days of that. And so in future representation, we would have to pinpoint the issue post-entitlement, and we'd have to get new legal representation agreements. 1696 MP agreements in place.
Yeah, I believe you're right. Mm-hmm.
everything we've talked about so far applies to the application and reconsideration, somewhat the hearing too, and I want to talk about that in a minute. But at application and reconsideration, and this conversation will be real quick, if you're denied, what are your options?
You have the right to file an appeal, and depending if it's an application, you appeal and request reconsideration. If it's at reconsideration, you appeal and request a hearing. I think this is something worth making a very short podcast on, targeted to folks who don't have representation, because oftentimes we are seeing our newest clients come in and say, I've applied in the past, I got denied, I didn't know that it's expected you go through this appeal process. Sometimes folks believe that if they get that initial denial from Social Security, it's not worth appealing because it's just a waste of time. Whereas it's almost the opposite. It's and I don't agree with this process, but it's almost expected that if you are going to win your disability case, it's because you've gone through the appeal process and eventually had your case heard by a judge who got a chance to have that one-on-one direct conversation with you, asking you the important questions to ultimately approve you for benefits. So if you get denied, my strong recommendation would be in the vast majority of cases, your lawyer can advise you differently, but be prepared to have an appeal filed or to file the appeal on your own. Just because you get an initial denial, I wouldn't say that means you don't have a legitimate disability claim. It's just the way that the sausage is made now at Social Security is it's almost expected that you'll get a denial, you'll get another denial, and you have to go through the appeal process, have your case heard by a judge, and then the odds finally flip in your favor of getting an approval.
There are some serious legal consequences to not appealing that I don't think people are aware of. I think it's confusing in the denial letters that folks get because it actually says you can appeal within 60 days or you can reapply. And so I think in a lot of ways, people have just gone through that application process, so they know it. So that they just lean towards that because I'm familiar, I've gone through it, I can reapply. What the decision doesn't talk is about the legal consequences of not appealing. And you and I could do a whole podcast on res judicata and the effect of not appealing and when res judicata kicks in. So obviously I don't want to deep dive into that today because that's a little bit more complicated and can take some time to talk about. But you're absolutely correct. You have 60 days or 65 days. They give you 5 days for mailing from the date of the denial letter. And if you've denied an application, request a reconsideration. If you're denied a reconsideration, you have 65 days to request a hearing before an administrative law judge. Now, to your point, I think current statistics show there's about a 60% denial rate, give or take, any given year, as high as 65, 70% denial rate at application, as high as 85% denial rate at reconsideration. The national average in winning cases at hearing, I think, is around 50%.
55, yeah, closer to 55. So slightly, yeah, more than 50%.
So that's the national average, but it's also judge dependent too. Like if you get assigned to a judge who pays 20%, you're kind of stuck. You know, you can't pick and choose your judges. I wish we could, but we can't. So that's great if you're denied. Now I want to talk about the hearing level, and let's just stick with denials. If you're denied at the hearing, you go to in front of a judge. The judge has, again, those same options, fully favorable, partially favorable, or denial, or a closed period. Mm-hmm. If you're denied, at the hearing, what's your next option?
Yeah, that would be filing an appeal to the Appeals Council, panel of judges. There's one in the whole country. I think they're out of the Baltimore, Virginia,
Falls Church.
Falls Church. They may have moved out of Falls Church. I think so. Very recent.
You might be right.
But they're in that that greater Washington D.C. metro area for federal agencies. But that is the next appeal level after a hearing. If you disagree with the judge's decision for any reason, again, if it's a partially favorable or an unfavorable decision, or even a dismissal, which big deep dive on what the difference between a denial and a dismissal is, I'm sure is a good topic. But the next appeal level is to the appeals council, and another office with a high denial rate and a long wait time. But still, to your earlier point, the importance of filing an appeal remain, I would say, after a hearing decision, to not accept Social Security's unfavorable as the final decision in your case. Again, you can talk to a lawyer about your specific case, whether it makes sense, but the general analysis that I would have, that I would lean to in any given situation, is first to analyze that an appeal makes sense, rather than to say an appeal wouldn't make sense and it'd be better to start a new claim. In rare exceptions, it may make sense to start a new claim, but making that legal analysis is part of the job, part of our responsibility as disability representatives.
And do you know what the current win rate is at the appeals council?
I imagine it's around 15%. Yeah, so a denial rate of about 85 is what I predict. Again, fluctuates from year to year, but not dramatically.
And then after the appeals council, a claimant has literally exhausted all their appeals within the Social Security Administration. But what options do they have next, if any, for an appeal after the appeals council? And just
you could take your case to federal court. You just had a podcast about suing the Social Security Administration with our wonderful colleague Isabella, an attorney at law who does that type of work, of essentially saying, well, Social Security made their final decision. They said there's no more appeal rights, so we're going to the next level, which is to file the case in federal court and have a federal judge decide, did Social Security actually get the decision right, or did they commit harmful legal error and need to have their decision overturned?
Right. And so if you're denied, you can take it up to the federal court level, and then technically you have United States District Court, then you have your Circuit Court of Appeals, Circuit Court, and then you have the United States Supreme Court. So, and then I just got a note from one of our assistants that they have, they're in Baltimore, Maryland, the Appeals Council, but they're headquartered in Falls Church. So
confusing. Yeah. I just noticed that at some point. Yeah. The address from the Appeals Council letters changed from Falls Church to something in Baltimore. But it's the federal government is gonna move offices when it needs to and open up satellite offices as necessary. But yeah, over on the East Coast, hopefully
they expand more, because it's a 12-month wait at the Appeals Council with an 85 to 89% denial rate on any given year. So one thing I wanted to just clarify, because it is a little bit different. Now we've talked about kind of the pathway if you lose. But if you win at a hearing, what happens then after kind of your options of winning? Because a lot of times it can get a little confusing for our clients. They'll ask, from time to time, does the judge determine my pay? Does he determine my deductions? Does he determine my monthly amount? What happens technically with the case? In your typical case, because judges will sometimes review non-medical cases, but 9 times out of 10, at least, the judge is just looking at the medical question about your disability. Do you meet the medical definition for disability according to Social Security's rules? And if you get a fully favorable decision, or even a partially favorable decision, that means, yes, at some point in time, the judge agrees that you meet Social Security's definition of disabled. But the judge is not the one who determines how much money you get. 9 times out of 10, the judge is not looking at those non-medical questions about your eligibility. So for a DIP case, a Title II disability insurance case, SSDI, if you get a favorable decision from a judge, it's pretty much, I'd say 95% of the time, smooth sailing. I've never encountered an SSDI claim going off the rails after a favorable medical decision. I'm sure it's happened, but I haven't seen it myself.
But if it's SSI, that thing we talked about again earlier, the pre-effectuation review conference, the PERC, that's going to be done by your local office. The judge is going to issue a decision, send it to the local office saying, this is the period of disability for the medical question. Now go complete the pre-effectuation review conference, figure out, did this person have the non-medical requirements for their SSI benefits, specifically that question of resources. What was this person, what did this person have in terms of resources during this period of disability that my decision very clearly put in the decision. The start date of disability, is it ongoing or did it close? Now the local office will make their review of your resources for SSI eligibility, both past due and ongoing.
Yeah. So just as a quick kind of recap, it goes into if you're denied at application, you request that appeal, denied it at reconsideration, request a hearing for a medical determination, meaning no one's found you medically disabled, meaning you can't work, or they think you can work and make over SGA, substantial gainful activity. That's what the judge is determining. I would say, from, I don't know the exact statistics, but I would guess 80 to 90% of all hearings are kind of formulated around that.
Yeah.
If the judge finds you fully favorable, then your case is sent back down to your local office for them to determine your payments and all of that, even the monthly amount. Mm-hmm. That's Title II or Title 16. Mm-hmm. And then if it's a partially favorable, your appeal rights go to the appeals council.
Yes.
That goes up the chain. So that's important to know. And then if it's a partially favorable from a judge, then it's the same warnings we talked about earlier that you can lose what you got. Now, the other, 10 to 20% of the time, or, we're guessing, that a judge may be determining, especially in SSI deductions or, a technical reason, is that you've actually appealed that technical reason from the application to reconsideration and requested a hearing on the technical side of it, meaning I disagree with these deductions, or I disagree with this overpayment or offsets or whatever. That technical aspect can end up in front of a judge as well.
Yeah.
So and that's the path, and all the way to the appeals council. And technically, you could probably appeal that to technically you could appeal it to the federal court as well.
Yeah, I imagine so.
And so those are things that are a slight distinction at the hearing level. Is that the judge, that although may find you medically disabled, most of the time is not going to be sitting there figuring out your back pay. He or she is not doing the math on that, or even your monthly amount. And in fact, I think a computer does most of that.
Yeah.
Anyway, is there anything else that we haven't covered in today's podcast regarding deductions, or options on a fully favorable or unfavorable? And the SSI amount is $943 this year. And so that it's great, because I remember it being, when I started as a young lawyer, as low as like $500 or $600 a month. It was crazy.
Yeah. To answer your question, I'm sure there's many things that the nitty gritty of things that cannot just be covered in a podcast. We hit the broad strokes, and I think we've given both our clients and anyone who's interested in Social Security disability useful information. But the nuances of your specific case are things that this is your life and your survival. It is worth the deep analysis that a legal expert, a qualified legal expert, should be providing you, because as much as we can say like, oh, this is true in 90% of cases, or this is the rate is X amount of percentages, the nuances of your case, the specific details, that's where the devil lives, that's where God lives, is in the details. So it's worth having the individual analysis of your particular situation, whether it's, I just got a decision from Social Security that's it's confusing. It says I'm disabled, but of a different date than what I allege. What does that mean? I strongly recommend having a qualified eye take a look at your situation and providing a qualified analysis, because it's so much more than can be covered even in an hour-long detailed podcast between two people who've been doing this for a solid chunk of time. One of them a lot longer than the other, by the way, and that would be you. Just to make it clear, I think like at least 4 times as long as I've been doing this, at least. But yeah, it still matters to have an expert, or at least a qualified individual, if we want to be humble and not use the term expert, but someone who has done this and has the experience to make the analysis in your case. This podcast, I love how it reaches people and the feedback we get from it. I wouldn't say it is a substitute for the type of individual attention that your disability case deserves.
Right. And I think every case is unique. I mean, I get questions, in the comment section, and sometimes I respond and sometimes I don't. And it kind of depends, because a lot of times, cases are so unique with so many nuances, and it can just open up a can of worms where I really need to understand more than what the person's just asking in order to answer the question. That's right. That's exactly right. There's not just one thing to look at in these type of cases, like especially like a partially favorable or a closed period. There's multiple things to look at. What are you fighting for? How much money are we talking about? What's the risk? What's your medical record say? What's your date last insured? What office are you at? What hearing office do you feed into? Because if you feed into Alaska, for example, in their office, that may be a different determination than if you feed into like a Spokane, Washington, or a Tacoma, Washington, where the judges, you have more options with judges. So there's just a lot of factors, like you said, to talk to someone with experience who knows sort of what to look at. And it's not every lawyer. I mean, Social Security is such a unique area of law, So anyway, Mervin, thank you so much for your time. We'll do this again. I'm hoping to do it again soon. I'd love to do a podcast with you and deep dive into CDRs, because I think that is a big question that we get from, especially clients that haven't been with us in the past, which we don't take those cases. If you were a current client or an old client and we actually won your case and you come up on a CDR, we will help you. Unfortunately, we can only do so many of that due to internal firm resources, because in many of those cases, we're basically doing it pro bono for free. And so if you're having a CDR and you weren't with us and you did have a lawyer, I would reach out to your lawyer who handled your disability case to see if they will help you, advise you on your CDR cases or your overpayment cases, post-entitlement cases. But we should deep dive and maybe do a podcast so we can talk about things that they can do, things to expect, because they're entitled to a hearing at the local office, which is a unique thing in and of itself, and go from there. Okay?
Exactly. 100%, sir. Thank you for your time.